The issue of returning foreign fighters is a concern for many states and continues to gain a lot of media attention. Prosecution is one part of the solution to this complex phenomenon. Yet, who are these foreign fighters? UN Security Council Resolution 2178 from 2014 defines foreign fighters as terrorist fighters, namely individuals who travel to a state other than their state of residence or nationality for the purpose of the perpetration, planning, or preparation of or participation in terrorist acts or the providing or receiving of terrorist training, including in connection with armed conflict.
The law criminalising the conduct of foreign fighters can be categorised under two headings: international criminal law and the law on international terrorism. International criminal law is relevant where a foreign fighter is accused of having committed an international crime while fighting for IS, such as the crimes of genocide, war crimes, and crimes against humanity. The law of international terrorism criminalises acts such as travelling to another country to join a terrorist organisation, training others to commit terrorist offences, and the commission of terrorist offences. Under international criminal law, when a returning foreign fighter is accused of committing an international crime abroad, the state to which they return may be able to prosecute them through the exercise of extraterritorial jurisdiction. Here, the prosecuting state has jurisdiction to try the offender under the nationality or active personality principle and the passive personality principle. The nationality or active personality principle allow the state of nationality of the accused to try the alleged offender, while the passive personality principle allows the nationality of the victims to try the accused. Where there is no link between the extraterritorial crime and the state seeking to prosecute the accused, universal jurisdiction allows any state to prosecute a foreign individual who is suspected of committing genocide, crimes against humanity, or war crimes abroad. However, these principles must be incorporated into domestic law. Details of the incorporation of these principles into Irish and UK domestic law is provided for on these slides.
The Irish legislation on terrorism can be categorised under two groupings: the laws that were created in response to the domestic terrorist threat and the laws that were created in accordance with the International Law on Terrorism. At present, the Criminal Justice Terrorist Offences Act 2005 criminalises the following conduct, which is also relevant to the issue of returning foreign fighters: membership of an unlawful organisation, participation in unauthorised military exercises, engaging in terrorist activity, and recruitment for terrorism. The Criminal Justice Terrorist Offences Amendment Act was signed by the President on the 1st of June 2015. This Act amends the 2005 Act to create three new offences of public provocation to commit a terrorist offence, recruitment for terrorism, and training for terrorism. These offences can carry sentences of up to 10 years imprisonment and gives effect to the Council of Europe Convention on the Prevention of Terrorism and UN Security Council Resolution 2178. The UK has also introduced Counter-Terrorism and Border Security Act 2019, which has introduced new terrorist offences.
A recent Human Rights Watch report detailed that many states are addressing the issue of foreign fighters under domestic implementation of UN Security Council Resolution 2178. It should be noted that there are many difficulties in conducting prosecutions of foreign fighters for international crimes they are accused of having committed abroad. These include difficulties in accessing evidence, information and witnesses, and securing the cooperation of involved states. It is arguably easier to access evidence of an individual leaving their country of residence to join an illegal organisation abroad. We note that while foreign fighter prosecutions have been initiated in some countries, the fate of many of these men, women and children has yet to be determined as states grapple with how best to manage this situation.